Same-sex couples now have the constitutional right to marry. The justices ruled today in a 5-4 decision that states cannot deny marriages to couples simply because they're gay. Our Statehouse reporter Brandon Smith has been following this issue since same-sex marriage was first legalized in Indiana last year. That, of course, led to a number of legal challenges, which the Supreme Court tried to stay out of, but ultimately had to get involved, and that's led us to this landmark decision. Brandon, thanks for being here. In Indiana, same-sex marriage is legal. So what does this change in Indiana today?
Well, it essentially just maintains the status quo within Indiana. As you said, as of last October, same-sex marriage has been legal in the state. Today's ruling doesn't change that. However, it does mean that marriages in Indiana can now be recognized in all 50 states. And as one of the plaintiffs in that Indiana marriage suit, Pam Lee, said at a rally today, today's ruling means that she and her wife no longer have to worry about being torn apart in the future.
Brandon, you're there at the State House. What's the reaction there been like from state leaders?
Democratic leaders are unanimously celebrating today's ruling. That includes statements from the State House Democratic leaders, U.S. Senator Joe Donnelly, the state party Democratic gubernatorial candidates John Gregg and Glenda Ritz. Republicans have been a little less vocal. Republican U.S. Senator Dan Coates reiterated his support for so-called traditional marriage and the need to now defend religious freedom in the country. State Attorney General Greg Zeller urged respect for the decision, even from those who disagree with it. And Governor Mike Pence expressed his disappointment in the Supreme Court's ruling, but said that Indiana will abide by the law, and said that Hoosiers should be assured that the state will respect every Hoosier family.
159,000 Hoosiers will get to keep their health care subsidies after the U.S. Supreme Court upheld the subsidies in a ruling released yesterday. It's one of two major decisions the Supreme Court is making this month. The other is on same-sex marriage. We'll talk more about that in a few minutes. But first, what did the health care ruling decide, and what are the implications? The court was considering one line in the health care law that said subsidies would be available to an exchange established by the state. Some argue that meant health care subsidies should only be available to people in states that set up their own exchanges, not through the federal marketplace. Indiana was one of 34 states that did not set up a state-based exchange, so that meant 6.4 million people nationwide and 160,000 Hoosiers could have lost their health care subsidies. Healthcare experts say that would have skyrocketed healthcare premiums. The average subsidy in Indiana was more than $300. So if the subsidies had been struck down, monthly premiums could have tripled. Instead, Professor Kasali Simon says Indiana can continue to focus on getting people signed up for insurance.
The Supreme Court is taking a firm stance on saying we understand the intent of Congress was to stabilize insurance markets. That means that they're putting heavy weight on the fact that they understand the intent of Congress to have been to improve health insurance markets, and that without the subsidies, these are marketplaces that would not survive, would not be functioning well. And the reason is that without the subsidies, the uninsured are insured because they can't afford health insurance, and that at any price, the people who would buy health insurance are going to be the ones who need it the most, or are sicker, and that would cause premiums to rise.
Health insurance providers praised the decision. The Indianapolis-based company Anthem, the nation's largest for-profit health insurer, said yesterday it's pleased that the Supreme Court ruling maintains access to coverage for subsidy-eligible individuals across the country, and they look forward to continuing to play an integral role in expanding health care coverage for more Hoosiers. But Republicans were not pleased, saying the ruling gives credence to Obamacare. Governor Pence issued a statement that said the ruling is, quote, profoundly disappointing to me and every Hoosier who had hoped this ruling would give our nation the opportunity to start over on health care reform. He calls the court's order judicial activism that upholds a deeply flawed law to the detriment of millions of Hoosiers. Nevertheless, the court's ruling is the final word. There are a lot of moving parts in both of these cases, and there are sure to be consequences for years. So to talk about those, we're joined by two experts in these areas. Chris Schrader is a human resources professional, and Ryan Scott is a law professor at the IU Maurer School of Law. Ryan, let's start with you in the same-sex marriage case. Is this a decision that everybody was expecting?
It's the result that most people who are court watchers anticipated, but the rationale is somewhat surprising, and there's always a little bit of uncertainty around a landmark decision like this. It's a major victory for proponents of marriage equality for same-sex couples, and sparked strenuous dissent by all 4 justices in the dissent, wrote separate opinions to express their dissatisfaction with the outcome. So roughly what we expected, but perhaps a little bit different in its rationale and in the way that the consequences that the opinion will have going forward.
Well, and it was close. It was 5-4. So what was the heart of that debate that made it that close?
The majority opinion written by Justice Kennedy expounds upon the due process clause of the 14th Amendment and adds to it an analysis of the equal protection clause. It's doctrinally, it's actually a little bit confusing, and a lot of people, even in the few hours since the opinion has come out, have criticized the rationale that Justice Kennedy uses, thinks that it's malleable and that it's going to be difficult for courts to apply going forward. It seems like the kind of rationale that only applies to this case and would be tough to expand in future cases. A very different rationale, for those of you who followed the Indiana case that the United States Court of Appeals for the 7th Circuit decided about a year ago. That case was a more straightforward equal protection analysis. Justice Kennedy, as he sometimes does, chose a different path to get to that result.
So are both of you, Chris, surprised by the timing of these rulings?
I did not expect them to be one day after the other. I thought there might be a little bit more of a stagger, but clearly they wanted to get these out and get it done before the holiday.
What kind of impact does that same-sex ruling have on the health care issue?
On the health care issue, it will go more along the lines of health insurance. From a human resources perspective, we really don't get that involved in people's marital lives. But when it came down to things like 401k, life insurance, and medical insurance, there are specific rules that apply to a person's legal status as a spouse and how they are treated and the rights they have within those. So this clarifies that.
You know, there have been multiple lawsuits regarding the Affordable Care Act. We can go back to 2012.
Yes.
Does this Supreme Court ruling have any type of effect on the stability of health care now?
Well, yes and no. Probably more in the legal arena than in the fiscal arena and the legislative arena. I think this does put to rest main force legal challenges to it. It's pretty clear to me, at least, this court does not have appetite for overturning the ACA. And so this now firmly puts it into the legislative arena. But one thing is clear, and there was a big sigh of relief, I think, from a lot of the state exchanges in this regard. About half of them are struggling and financially underwater. 4 have thrown in the towel and are switching over to the federal exchange for next year's open enrollment. Another 5 have no path to the solvency required in the Act in 2016. So now there is a clear path to be able to easily retire those exchanges when and if they melt down and put them into the federal exchange without a lot of sturm and drang.
Ryan, do you agree?
Yeah, the decision certainly puts states in a position where they can more freely elect to create their own exchanges. If the court had come out the other way here, that would have put a lot of states, including Indiana, in a position where they need to either create an exchange of their own or hope that Congress stepped in and made changes that extended subsidies to others, regardless of the exchange. You heard Governor Pence's quote where he talked about starting over on health care reform. I do think that the folks who were disappointed in this ruling saw this as a chance to eliminate subsidies for a large group of people, not because they wanted that to be the resting point, the final result of the health care reform effort, but to use it as a bargaining chip in a new round of negotiations over what the health care plan would look like. So, for example, to eliminate the individual mandate or to make other changes to the Affordable Care Act that they've been proposing for a while. Instead, it's the status quo. The Obama administration gets a big win, and the health care law now will operate the same way regardless of whether the state or the federal government created the exchange.
15 seconds.
Yeah, ironically, it does create a strong disincentive to ever start another state exchange. I think how many you have here will just go downhill from there.
Okay, thank you both for being here today. Appreciate it.